So I wanted this April Prayer, criminal defense attorney from Chicago, the justice junkie, and I wanted to do a follow-up to the carjacking video that I did a little while ago because of this rash of carjackings in Chicago by teenagers. And the teenagers seem to be getting younger and younger and younger. And even though I've been doing criminal defense for a long time, I've done only a smattering of juvenile cases here and they're usually attached to a police brutality incident. So that's usually how I end up with those cases because most families don't hire private counsel for juvenile matters. But so I brought in experts. I brought in my good friend of about 20 years, Courtenay Harris-Black, who I have known from the beginning, just about of my time in the public defender's office, where we were partnered up in the same courtroom, and we just hit it off right away. We talked for about 10 minutes, and I found out that I went to elementary school with her husband and her sister-in-law, and then we talked a little longer, and I found out that her mother-in-law was my kindergarten teacher. So we were just meant to be friends. So I'm going to introduce you to Courtenay Harris-Black, who is an assistant with the public defender's office here in Cook County, and she's assigned to juvenile delinquency. So she's going to talk to us about the differences between adult court and juvenile court. But why don't you say hello, Courtenay, and tell us a little bit about yourself?
Hello, April is right. She is a dear friend of 20 years. I am an assistant public defender with the Cook County Public Defender's Office. And I have been working as an assistant public defender for 20 years. Today is this year is my 21st year. Prior to that, I worked for the Department of Children and Family Services as a staff attorney, also in juvenile court, where I worked in the civil division, which encompassed the abuse and neglect courtrooms, as well as the delinquency division. So I've been working in the juvenile justice court for almost 25 years in total. So it's been a long time. Yeah.
I forgot about your background before becoming a public defender. I forgot all about that. So a lot of people have been watching the news and seeing these 15-year-olds get arrested for carjacking. And that has obviously brought up a lot of questions because people simply don't know how it works. So why don't you walk us through it? If I am a 15-year-old, I get arrested for vehicular hijacking, what happens to me from the point of arrest?
So from the time that a young person is arrested and taken into custody, the initial step will be that they would be taken to a police district station. The police are required to notify the juvenile's parent or guardian that they are in custody because the parent or guardian has the right to try to contact and speak with the minor while they are detained. While the minor is in custody, if actually under arrest and charged with certain offenses, and the police actually interview the minor, they do have to video record the minor with certain felony offenses. So that is something very important. The minor has the right to be appointed counsel to assist him or her with anything that goes on at the police station. And in response to this, Amy Campanelli, the current public defender, developed the police station response unit. So I do want everybody to know that if you or a loved one is arrested and taken into custody, both for juveniles and adults, the first thing you should do is lawyer up. And I know that that's a key fundamental point that you often make, but the police station response unit is available 24/7 for juveniles and adults, and a public defender can and will come out and meet your juvenile at the station. So the first thing when a juvenile is arrested is that the police officer should reach out to a parent or guardian, and the minor should shut up, lawyer up, and have a lawyer come meet them at the station.
My first question is, what if, and this I would imagine happens quite a bit, what if that child's parent or guardian can't be reached? Maybe mom is in the streets, maybe dad is in prison, maybe he lives from house to house. What happens if no parent is reached?
Well, there's the ideal what happens, and there's in actuality what happens. Ideally, if a parent or guardian can't be reached, there would be a youth officer, a special detective who theoretically has specialized training to sit and protect the minor's interests while the minor is being questioned. That having been said, that is a police officer who will be assisting the police in the investigation of any or all offenses. So the minor does still need an attorney. If a parent or guardian can't be reached, somebody from the police station response unit can and will come out to sit and represent and speak with the minor. If housing or a place or somebody to release the minor to becomes an issue, the police often contact the Department of Health Services to get the minor to a temporary shelter situation somewhere like Aunt Martha's.
Now, what if mom is reached and she comes to the police station? Before she gets there, is the police officer allowed to talk to her kid? Does he have to wait for her to arrive?
With certain kinds of charges now, you are supposed to wait for a parent. However, they don't always do that, and they don't have to in certain circumstances. Really, if the child invokes their right to counsel, the police need to wait for counsel to arrive. They should wait for a parent or guardian to arrive. That is within the police's own rules of procedure. They are supposed to wait for a parent or guardian to arrive. They often don't give parents the opportunity, and many parents in my experience have been given the runaround. They're told by one officer, your child's being taken to a certain district, and then it turns out on the way to that district, they're rerouted, or that was never the intent to take them there, or that they're held and detained at the site of arrest before they're brought over. So there's a lot of confusion there. And I know many parents are upset when somebody attempts to speak to their child without them being present. Although in some cases, police can speak to a juvenile without a parent or guardian present, so long as if they've invoked, there is a youth officer present and an attorney.
So once the kid is arrested and taken to the police station, what happens next?
So while the minor is detained in Illinois under the Juvenile Court Act, a minor can only remain in custody and must be brought to a hearing, an initial hearing, within 40 hours. So in that 40-hour period, the police are supposed to make a reasonable attempt to contact a parent or guardian. If they can't do that, ideally they contact another responsible adult. If they can't do that, they are supposed to have a youth detective or attorney present for the minor. The minor is going to be in a lockup room, often on a tin bed with a thin mattress. They are actually on video the entire time. I like to remind clients of that. Sometimes clients speak to themselves, talk out loud in an effort to try to process what's going on. Also, when parents are allowed in to see their minor children, they are still on video as well. So be very mindful of that. When you think you're alone in a room, there are still eyes and ears on you listening to a conversation you might have with your child.
Yeah, that's yet another reason. That's why I have to tell people, even adult defendants, like, don't talk on the phone when you're calling your mom and you're frustrated and telling her how it is you got arrested. Don't tell your girlfriend when you're calling from the jail, because those calls are recorded. I tell clients, don't even tell me anything in the police station, because I don't trust the surroundings, because I know of at least one attorney on a murder case whose conversation was recorded by CPD. So I just tell them, don't talk until we're in a secure setting to do that. So after the kid is housed in this, I call it juvie jail. Once he goes to juvie jail, how long is it before he goes back in front of a judge after that initial hearing?
Okay, so I will make the distinction between juvie jail and detention at a police district, only because when you're detained at the police district, you're kind of in at a police station in a room, a barrack-like room. When you are brought to hearing, which is called an arraignment hearing, it's the first appearance before a judge, ideally within the 40 hours, because here is something the public may not know. If the police violate the 40-hour rule, the minor can no longer be held, despite what the charges are. So public defenders and all attorneys and parents should be very mindful of the time the minor was arrested and went into custody, because now with the establishment of holiday bond court, meaning that a bond type court occurs every day in Cook County for juveniles now, including the weekends. So the 40 hours runs on the weekends, although not holidays, not Christmas, if your child was not brought to court within 40 hours, the child has to be released. And that mistake would be on the police. And so many people might question, how is this child walking? That's one reason a child might walk out of custody in an arraignment hearing. But after the child minor comes in and is arraigned, depending on the outcome of that arraignment will depend when that minor next appears in court.
And what's an arraignment? Explain what an arraignment is.
So an arraignment is a first appearance, and in juvenile court, it's a two-part proceeding. The first part is whether or not there is probable cause to believe that a crime occurred. The second part is an urgent and immediate necessity determination to determine whether or not a minor should be detained in a secured facility or released to a detention alternative. The probable cause standard is very low. It usually involves the state's attorney reading a very simple summary of what happened on an initial police report. And again, not what actually happened, but what happened according to the police and the victim, quote unquote. And the judge will 99% of the time find probable cause. The really important part is urgent and immediate necessity. And what goes into an urgent and immediate necessity finding? Well, the severity of the offense is a big one. That is a big determinative as to whether or not a minor could or would be held. The age of the minor, the minor's history in juvenile court or history of police contact, the minor's history of warrants, if there are any, the minor's history with the Department of Children and Family Service, the minor's educational status, whether or not they are a special or regular education student, whether or not there is a safe and stable home for the minor to go to. All these kinds of things come into consideration for an urgent and immediate necessity determination. If the court decides that there's urgent and immediate necessity, the minor can be held in custody at the Juvenile Temporary Detention Center, which is what we call juvie jail, otherwise known as the Audi home, or the minor could be released on some kind of detention alternative like electronic monitoring with a GPS monitor. Now, as of the last couple of years, all electronic monitoring devices for juveniles are equipped with a GPS monitor. And although the minor is out of custody, it's still a form of custody. So that is one option.
So do you find that in the era of COVID, that say that 15-year-old kid that I said is accused of carjacking with a weapon, is he inclined to be held in the facility, or is he inclined to be released on electronic monitoring with GPS?
So again, there are a number of considerations that would come into this determination. One, how many people were involved or allegedly involved in the vehicular hijacking? Two, what kind of weapon was involved? Was it a firearm or was it something else? Was it an everyday instrument that could be utilized or threatened to be utilized as a weapon? Was the minor accountable or merely present? These are important considerations for a judge who's going to be making this kind of determination. So For example, a 15-year-old who was driving the car and never got out, or the 15-year-old who maybe got out and made some kind of aggressive stance, but didn't actually hold the weapon. Those would be looked at differently, particularly if those minors had an absolute lack of criminal background, they were otherwise going to school. Right now during COVID, there is a push to get young people and adults as well out of custody. The rates of COVID infection are very high, and both for detained minors and for the staff. So there is a push to keep minors out of the detention center. So, for example, if a young person came in, so again, there are a lot of considerations. I'd have to know more specifics, and the judge probably would too. Also, a big consideration is, was anybody hurt? For example, there's a difference between the threat of force and the use of force. If somebody was beaten with the weapon, or if the weapon was held while the person was beaten and there was bodily injury or great bodily injury sustained, that would change the determination.
Okay, and I'm glad that you pointed that out, because I often have to explain to people that an armed robbery or carjacking doesn't have to be done at gunpoint. It could be done with a pipe. It could be done with a stick. It can be it can be done with just the force of your body. And so all of that makes a big determination in how much time you're looking at if you lose your case or you plead guilty and you're sentenced, and also in terms of whether you're held pretrial or whether you're released in some way. So
absolutely. It also makes a difference in the class of offense, honestly, because there is the charge of vehicular hijacking, which is the taking of the vehicle from the immediate presence of a person with the threat of the use of force. And then there is aggravated vehicular hijacking. And there are many different factors that could go into what would substantiate an aggravated vehicular hijacking charge, but one of them is having a weapon and using it, or having a firearm.
So let's jump ahead. The kid has gotten charged. Let's say he's being held in the Audi home. And how long will he have to wait before he actually reaches trial? Because, on the adult side, things move pretty slow. He could very well be sitting for 2.5 years, especially in the midst of COVID, waiting pre-trial. I know that things move a lot faster on the juvenile side. So how long on average, obviously, in Cook County does that kid have to wait being held before he reaches a trial date?
So if at arraignment a young person is held, the Juvenile Court Act specifically states that a minor can only be held for 30 days pre-trial before they need to be released. So if the case cannot come to trial, and remember, for most juveniles, it will only be a bench trial. Juveniles do not, except in very limited circumstances, have the right to a jury trial. And the charge of vehicular hijacking and aggravated vehicular hijacking is the kind of charge that would receive a bench trial. So the Juvenile Court Act says specifically 30 days pre-trial, or the minor needs to be released. Now, there is a very limited exception for that. If there is great bodily harm found, if the victim is severely harmed with some kind of permanent bodily injury, the young person could be held up to 70 days pre-trial before the minor would have to be released. However, judges play fast and loose with this, as does the state. Minors come in, they're held. A public defender might say, I need to go, or a private attorney, I need to go by agreement because I don't have any discovery yet. I need to do a proper investigation. I need to interview witnesses. I need to find body cameras, in-car cameras. And some judges confuse or conflate the issue of by agreement and demand for trial with the very clear juvenile court provision that says a minor needs to be released in 30 days if not brought to trial. And so judges, with their misinterpretation of that, and the public defender's office has been trying to work on this, often say, the public defender went by agreement, So we're going to continue to hold the minor beyond the initial 30 days. In the period of COVID, we have found kind of mixed bags. Some judges are more receptive to stepping minors out of custody after 30 days because they can be placed on an electronic monitoring bracelet with a GPS chip. And that allows a special probation unit to monitor 24/7. They have officers in monitoring the minors' whereabouts, and it's very accurate technology. It can tell whether you're inside or outside of the house, and whether you're in the yard or on the porch. So that has given judges a greater feeling of security, particularly when trials are not really happening right now.
If a kid has the GPS bracelet and he participates in a crime, he leaves the home, he's on the other side of town, do officers then jump in a car and go pursue him right away? Or what happens?
No. So the monitoring officers will make a violation report, and they will try to check if it seems like something like, oh, the minor appears to have just gone slightly outside the zone, the home zone, and they appear to be, and they can see where they are. Are they at the street? Are they at their school? Are they at grandma's house who lives on the next block? They might make an inquiring phone call. Hey, we see that you're out of the home zone. And a good officer will look into that, try to verify where the minor is. If the minor is way out of pocket in a completely different police district, in somewhere that they're not supposed to be, there might be an immediate violation filed. That the probation department doesn't file it. They would notify the violations contained within a report. They're supposed to send it to the state's attorney, the public defender's office, the probation department, and then the state's attorney would file a motion to violate, asking to revoke EM. So rest assured, especially as violent crime continues to go up in Chicago, that the probation department that is monitoring electronic monitoring is taking it more seriously. And we are seeing more of these violations come in, and more kids are being taken off the bracelet and put back into custody.
But that doesn't happen. Well, I asked you that because I know that one of the kids who recently got arrested had electronic monitoring. And there were a lot of people posting on Facebook. They wanted to know why, cops weren't Johnny on the spot. Why didn't they go snatch him up in that moment? I'm like, it doesn't work like that. It's a whole process of paper pushing that happens. And then maybe in a few weeks, he'll go in front of a judge and have to answer for his whereabouts that day. But it's not like you see on TV where they get an alert and somebody immediately rushes out to go apprehend you. It doesn't work like that at all.
No. And honestly, with the bracelet, the minor has to charge it for 2 hours a day, 2 hours at a time, not 5 minutes and 5 minutes and 5 minutes. You've got to charge it at least 2 hours at a time while awake and upright to keep the battery charged and keep the bracelet functioning. If a minor doesn't do that, it's going to be dead and not working. And therefore you will be pretty much in a situation where you could be charged with escape, one, which is a felony offense, and two, nobody can monitor your whereabouts. So if a bracelet goes dead, again, this is where the probation department should make a phone call home. Hey, what's going on? In some cases, we found the apartment or the house has lost power and they absolutely don't have the ability to charge the bracelet, or an emergency happened. Somebody went to the hospital. The minor was out of the home at the time the bracelet was up to be charged again. That's, sometimes that kind of thing happens. But if the minor is deliberately failing to charge the bracelet so that the whereabouts can't be traced, that is a violation. It will be noted and written into a report, sent again through the appropriate channels to the public defender, the state's attorneys. The state's attorneys will file a motion. The public defender will receive it. the probation department is supposed to notify the minor that there's been a violation and that they need to appear either in person or over Zoom. And if that young person is represented by a public defender, sometimes they're not yet, sometimes there's a private attorney or something else, then we are to contact our client and let them know that there are violations that have been alleged, and there'll be a hearing on it.
Okay.
And that can take several days to a week. And sometimes, as you know, more than a week, although recently, again, with COVID, things are like violations of that nature are coming in more quickly.
But people seem to think that drones come down upon you the minute you leave the area of your home and the police come and apprehend you. And I wanted to express that that is not the case.
That is not the case.
Under what circumstances would a juvenile be charged in adult court and not in juvenile court?
Okay, so as of 2015, and I did look this up to verify, there are only 3 offenses for which a minor could be automatically transferred to adult court. And those offenses are murder, aggravated criminal sexual assault, and aggravated battery with a firearm. The young person would have to be at least 16 years of age, so 15 would not qualify. So right now, under the laws that exist at this time, those are the only 3 offenses for which a minor could be charged as an adult, together with the age of a minimum of 16, for an automatic transfer to adult court. So aggravated vehicular hijacking used to be one of the offenses that triggered an automatic transfer, but it no longer does. And part of the reason for that, honestly, was that, and I looked at the legislative history for it, the Juvenile Justice Initiative looked into the filing of cases because automatic transfers are triggered by the state's attorney. Okay. So, and we found, or the Juvenile Justice Initiative and the public defender found, that race and racism color the conduct of the Chicago police and the court system. It's absolutely not questioned. And in the area of time that aggravated vehicular hijackings were studied, over 80% of the kids that got, the minors that were automatically transferred, were African American. Only 1 was white, and the rest were other.
Say that again.
Yeah. Of the Juvenile Justice Initiative, of the 257 children that were automatically transferred in a time period within the last, it was a short time period. It was a 2-year time period studied, but it was within the last decade. Over 80% were African American and only 1 was white.
1.
Those are alarming statistics.
That's outrageous.
Yeah.
Oh my goodness. So
And
frightening.
when you also think about how in 1998, the Juvenile Court Act was revised to take into account the very important essence of balanced and restorative justice, noting that children are fundamentally different than adults. The brain science is there. They don't have the same consequential thinking skills. There's inherent developmental immaturity. A lot of these things, these milestones there will be growth as they grow, as they grow and their brains grow. But the science says, the brain development isn't done until at least your mid-20s. So there are important reasons to treat juveniles differently, particularly juveniles of color, Black and brown kids.
Now I have a question. If I'm a 16-year-old and I'm accused of murder, where am I housed? Does that mean I go to Cook County Jail and I'm in there with other murder defendants who are 45 and 85 and 25, or where am I housed?
Yeah, so no. Under the procedures of the Juvenile Temporary Detention Center, all minors under 18 are housed at the Juvenile Temporary Detention Center, regardless of whether or not they've been designated as automatic transfers or discretionary transfers. Up until your 18th birthday, you will be housed at the Juvenile Temporary Detention Center. There was a change in the law a couple of years ago. It used to be that 17-year-olds were adults. And importantly, and again, the public defender's office worked to make this change. Importantly, now it is 18 and over who are now considered adults. So for many clients on their 18th birthday, because the juvenile court still has jurisdiction over our juvenile clients until their 21st birthday, so long as they don't pick up any adult cases. But many of them, unfortunately, on their 18th birthday are shipped over to Cook County Jail. The public defenders try to prevent against that by asking for special orders that so that any juvenile that's being held on a juvenile case can and will be maintained at the juvenile detention center until their case is resolved. But not all judges are willing to enter that kind of order.
Now, in terms of sentencing, so let's go back to our 15-year-old kid who's charged with vehicular hijacking, say it's with a weapon, say it's specifically a firearm, and he loses his case. What happens then in terms of sentencing?
So
someone was injured.
And someone was injured. Okay. If it's an aggravated, that would be an aggravated vehicular hijacking if there's a firearm. And if somebody was injured, meaning they were shot or they were beaten, two different things because it changes the charges. It would be aggravated discharge with a firearm, which is potentially an automatic transfer case. So if that was attached to the aggravated vehicular hijacking and they could come together, that might be a case where you're looking at adult sentencing. But assuming the case where it was just an aggravated vehicular hijacking without an aggravated discharge and it stayed in juvenile court, at sentencing for a minor, the Juvenile Court Act requires a written social investigation. This social investigation is a social history of the minor. The social history is prepared by the probation department. The probation department at that point would have collected all the records relevant to their determination of what kind of a sentence should be recommended. That would include school records, IEPs, which are special plans for special ed students, any history of mental health services or treatment or medication regimen. Again, any history of DCFS contact with the family or whether or not the minor is currently or ever has been a ward of the Department of Children and Family Services, whether or not the minor appears to be a good candidate for probation, whether or not this is somebody who, after being interviewed, and it's more than one interview, the minor is interviewed, the family is interviewed, anybody who the minor might reside with, as to what kind of household, whether or not the household could be supportive or even able to take a minor who's on probation. But assuming this is a 15-year-old first offender, and you're saying this minor had the firearm?
Yeah, he had the firearm.
He had the firearm and he did not discharge it, but somebody was injured. This minor would be probation eligible without a background. Even with the background, honestly. The term of probation could be up to 5 years and could also include a period of time on intensive probation. Intensive probation being that there's more contact with probation officers, there is a team assigned to you, there are more restrictions such as curfews, electronic monitoring, heightened conditions of probation, and so forth. But again, the idea when the Juvenile Court Act was modified to look at what kind of sentences should be available to minors, it took into account that minors are fundamentally different. They should be treated differently. And to that end, there are a lot of rehabilitative options that go into trying to give a minor the life skills so that they can become a functioning and productive member of society. So probation isn't always meant to be a sword for the minors. It can also be a shield, right? They can make, and I've seen them do it, make referrals for my clients to get college scholarships, to get special job opportunities, to get mentoring opportunities. So, so we often see kids do well on probation. It's not something I know the community wants to hear out of the gate, but
yeah, I knew that.
Yeah.
What is juvie life? You mentioned juvie life to me some time ago when we were just chatting. What is that?
So, as I said earlier, the juvenile court has jurisdiction over a juvenile's case until they reach the age of 21. So that is what we would call juvenile life. If a juvenile picks up a case before their 18th birthday, that case can and will remain a juvenile case, even after the minor attains the age of 18, unless it is an automatic transfer case or unless there's been a discretionary transfer hearing with the finding that the minor should be transferred, or there's an extended jurisdiction juvenile sentence imposed. Again, these are all kind of like complicated, sentencing options that we don't see very often, truly. But juvenile life would be commitment to the Illinois Department of Juvenile Justice, which is the prison system for juveniles until their 21st birthday. That would be juvenile life.
Wow.
So if you will, a 15-year-old who gets sentenced to juvenile life is significantly in a different situation than an almost 18-year-old who is sentenced to juvenile life for the same offense.
What do you see happening with this, a little off topic, juvenile sex offenders? If someone is charged with a sex offense, they are 15 years old, and again, they lose their adjudication hearing. What happens to them in general?
So with juvenile sex offenders, again, there's kind of a stratification of cases on whether or not it's a predatory criminal sexual assault, which is an X. And again, that's the kind of case that could be automatically transferred. And that kind of case, even as a juvenile, has lifelong ramifications, because if you are found guilty or plead guilty to that case, even if you are 15, you will be a lifelong registered sex offender. And up and until the time you are 21, you will not be able to go up on any social media sites. Your name will not be publicized. You would be on a registry that would be known only to the Chicago Police Department. But when you hit your 21st birthday, you would be registered and it would become public, just like any other sex offender. So universities, jobs, everybody would have access to that information. If it were a lesser kind of sex charge, criminal sexual abuse, or some kind of sexual battery, there are lesser terms of registration. There are 10-year terms of registration. If a minor is found guilty or pleads guilty to a lesser included offense of a criminal sexual assault, there could be a 10-year registration attached to that. With the 10-year registration, a 15-year-old would have the option after 5 years to petition to come off the record. This is a really important development in the last decade. It's a civil hearing that takes place in front of a special judge in juvenile court. The public defender's office doesn't do them, but Bloom Legal Clinic and several of the legal clinics will do them. And we will file the petitions for minors. But if you are compliant with your juvenile sex offender services, if you have maintained the registry, which literally means every time you move, you have to go to the police station in your new district. If your mom moves you, if with kids that have housing instability, it's super frustrating and can be a super hard thing to keep up with the registry. Also to understand that they're not allowed to be in certain public areas with children. They can't take jobs at a park district because children could be there. There are really significant ramifications to the sex offenses, especially when all the research has shown that juvenile sex offenders really are not the recidivists, and they're very receptive to services. And often we don't see any recidivism after somebody has successfully completed juvenile sex offender counseling. And a lot of the kids who are charged with this, we find, have been victims of abuse themselves. So yeah, but there are very significant ramifications, collateral consequences, as we say, to being found guilty or pleading guilty to a charge that has an imprimatur of sex. I will also say for juveniles that having consensual sex with your boyfriend or girlfriend, if you are under 16 years of age, that is a crime in the state of Illinois for which you can be charged with a felony sexual offense. So girls, and boys, if your partner changes their mind and decides you did them one wrong, or your parents find out, we've seen kids, and usually boys, in really terrible predicaments. So please be careful.
Yeah, and I think that I asked that question because I think there's this belief that whatever you do as a juvenile just gets sealed, that it's completely expunged, and that there's nothing you can do pretty much aside from killing somebody that is going to haunt you for the rest of your life. And I know I've seen cases of, I usually see it with 17-year-olds from years ago who had sex with their 15-year-old girlfriend, and suddenly now they're sex offenders who have to report for the rest of their, and they don't get it because their brains aren't done developing either, and they're like, what do you mean? And so they turn 17 and 18 and 27, and they don't understand that, they've gotten their lives together, or maybe they've even gone to college, they've gotten a trade, but they still have to report. And you'll have that one lapse in housing, or that one time that they forget to report, and now they've got really big problems as a result for failing to report. So I definitely wanted to point that out. You mentioned before that there are rare instances where a juvenile could have a jury trial. One, will that be a jury trial of other teenagers so that they are tried by their peers?
No, in fact, it is not a jury trial by other teenagers. It is a jury trial. And honestly, of your peers is used really loosely. The last jury trials I've done have been Caucasian juries from Park Ridge. So the voir dire was limited. Juveniles have the right to juries in limited circumstances. You have to be a certain age to be a juror, and that is the age of maturity. So you're not going to get teens. And often we don't really see, honestly, I don't see anybody really under 25 very often reporting for jury duty. I'm not quite sure why that is. Probably the younger ones are in school or somewhere where they're unable to report. But no, a jury is not a jury of your peers. When jury calls go out, it usually goes out by voting district. And so it'll call a bunch of people from that voting district. We don't often see some of the traditionally Black and brown areas pulling people in. We tend to see the suburbs. So you are going to be tried by adults that don't often look like you, and often have not had the same life experiences.
And that goes for adults too. Because you
Yes,
just
it does.
described several of my juries where I've had not only all white juries, but all white veneers, which is the jury selection pool that you draw from. So say they bring 40 people into the room, all 40 in some instances have been white. So it's very hard, if not impossible, to get 12 jurors of a mixed panel if the panel that's brought before you is all white. And that's very common in federal court, and it's more common depending on which courthouse you're at. You'll see it more in Skokie, you'll obviously see it in Rolling Meadows. Markham is very mixed, Bridgeview tends to be mixed. But and some of it's just crapshoot, depends on the day of the week and the day of the month as to who decided to show up for jury duty. That's why I always implore people to take jury duty very seriously, to show up, because that is your one opportunity to really do justice. And on that note, I'm going to ask
Absolutely.
you as a juror, and how from years and years and years ago, Courtenay sat as a juror, and she was an attorney at the time. So if you would tell us a little bit about your experience as a juror.
Yes. So when I was a public defender at the time, I was, responding to my civic duty, and I appeared for voir dire at 26 in California at the criminal courthouse. And the charge was aggravated battery to a police officer. I knew the judge. I had appeared in front of her as an attorney. I knew the state's attorney. I had worked with him. He was an acquaintance. It was not a public defender case. I probably would not have been appointed or selected for a public defender case. It was a private attorney. I was selected and impaneled. I was one of the 12. So I actually can let y'all know that showing up for jury service is incredibly important. My my group took ourselves very seriously. We did not talk about the case during the pendency of the case. We made notes, and I was actually surprised by how well everybody listened. I will say that when we went around and took an initial, what are we thinking? We were 10-2, 10 not guilty, 2 guilty. And the 2 people who believed that the state had proven its case, not necessarily that the defendant was guilty, but that the state had proven its case, 2 different things, were a very stereotypical kind of person who had had limited life experiences and couldn't understand, kind of the explanation for the defendant's behaviors, and that he was mixed. He was up in Wrigleyville during a Cubs game. He was drunk and acting kind of belligerent. But these are all things that have like different kinds of, they cast aspersions as to why anybody could be behaving like that, and why, if confronted with a police officer, he might have different kinds of concerns than a white frat boy drinking at a bar, being, having an encounter with police after a Cubs game. So it was interesting to me that, 1, how well people listened, but 2, how much they brought in their life experiences that colored how they heard the testimony and how they understood the story. So absolutely register to vote, and get out there and respond to your jury service, even if it's cold, even if you're not feeling well, even if you're, our kids need you when they have their juries, and definitely your peers need you. So.
Absolutely. Because it's all about bringing, like you said, bringing your life experience. And every judge will tell you, don't leave your life experience at the door. You take that with you into the jury room, because it makes a difference. If you can understand a part of the defendant's experience, or even in a civil case, part of the plaintiff's experience that your peers in that room cannot, that can make all the difference about whether that person actually receives justice or not. So on that note, I'm going to thank you for your time and for explaining so eloquently what happens in juvenile court. I know that, some of the terminology is different, but a lot of the process is very similar between what happens there and what happens in adult court. But we so often hear about adult court and don't so often hear about what happens to the babies in juvenile court. I do want to ask this last one. I'm assuming you saw the video of the 9-year-old Black girl who got pepper sprayed by the cops in New York.
Yeah, I made myself watch it.
Yeah, I did too. I had stopped several times.
Yeah, as a mother, and a human, it's really hard. Yeah.
Yeah, it is. And I just kept trying to watch and see what they were saying that she didn't do to comply. But I'm like, hey, based on these hundreds of body cam videos I've seen, I don't think the girl did that bad. She was just screaming for her dad. She was scared and cold. She didn't know any of these adults who were manhandling her. But my question to you is this: if a 9-year-old in Illinois, that was in New York, and if a 9-year-old in Illinois was being placed into police custody, where would they go?
Well, they would be brought to the police station, and sadly, to Cook County's discredit, 9-year-olds have been charged. There is no minimum age of accountability in Illinois. So 9-year-olds have been charged. They would be brought to a police station. These babies would be brought to a police station. And in the state, in Cook County, you can be detained in the Juvenile Temporary Detention Center at age 10. And the public defender's office tried to push legislation through in a House bill in 2018 to up the minimum age for secure detention to 13. And the Cook County commissioners passed an ordinance, but it went up, and the Illinois Supreme Court rejected the thoughts about that. So it is back to age 10. We often do not see kids younger than 14. Honestly, it's 14 to 17 are most of the kids we see there, because again, age is taken into consideration. at the arraignment at the first hearing for urgent and immediate necessity finding. But there have been 9 and 10-year-olds, 11, 12. In fact, the case that came up was for a 12-year-old who was held for several months. So kids, make no mistake, you can be held for months. And that 9-year-old baby would sit in a room by his or herself on a metal bed with a thin sheet on video. And it's absolutely horrific.
And that's the message that all the parents out there need to know, is that your 10-year-old, your 9-year-old can be taken into custody, treated just like the baby you saw on that video. And not only that, detained and kept away from you for a very long time. So juvenile justice in the United States needs a lot of work. We've been talking to you specifically about Illinois. This whole video, I'm sure I'll put a caption on there saying this is just about Illinois. If you live somewhere else, I'm sure some of it is parallel to what's going on here, but the terms may be different, the services may be different, the processes may be different. And so you should bone up on your state laws. So with that, thank you, Courtenay, for joining us.
You're very welcome. Yes.